Good day, everyone, and welcome to today's lesson. My name is Dooshima Adaguusu-Ngutswen, and we'll be taking a topic titled Forms of ADR. But before I begin, let me quickly paint a brief scenario. Folari and Fulake both spotted a good-looking watermelon, and there is an ongoing claim as to who was the first person that saw it or who has the right to claim it. Today we'll be speaking on the topic forms of alternative dispute resolution, also known as ADR. Let me quickly just share my screen. Okay, we all know that there are various ways of resolving disputes, but today we'll be focusing on ADR. What's the meaning of ADR? Alternative dispute resolution simply refers to means of dispute resolution outside the conventional courtroom or litigation. It is a form of facilitated process which is confidential and without prejudice. The following elements are a few characteristics of ADR system. It's flexible, which is like one of the highlighted advantages of it. It is speedy, there's quick resolution involved, and it's confidential, it is fair, it enables the parties to resolve their dispute without actually destroying their relationship. So ADR is a very important concept. Basically, in resolving dispute, primacy should be given to restoring the relationships rather than hurting the feelings or reaching a compromise. Reaching a compromise. We'll quickly look at a brief history of alternative dispute resolution. ADR is as old as man. ADR is as old as man, and even in the Holy Book, Jesus advised us that we should settle our dispute quickly while on our way to court, so that we are not handed over to the judge and the judge will hand you over to be hanged. It's always good to find a way to resolve your disputes in a peaceful manner so that create you can sustain the relationship that exists between you and your fellow human beings. There is no doubt disputes will always arise, but resolving it peacefully and restoring the relationship should be at the back of everyone's mind. Some characteristics of ADR, as I earlier mentioned, is consensual and voluntary. It's private. Such disputes is usually not to the public. Even when it's time to resolve it, it's not made public. Then it helps restore relationship. It is less expensive. It saves time. It's speedy, and it involves the presence of third party, which is usually agreed between the people involved. So now we'll go into the crux of the matter, forms of ADR. There are various forms of alternative dispute resolution. We have arbitration, we have conciliation, mediation, negotiation, and other hybrid processes. One will ask, why did all these things develop? The truth is that the litigation, which is the system we adopted from our colonial masters, has over the years proved very difficult in respect of time, in respect of cost. The courts are consistently overflooded with many cases. Some are actually frivolous, some are really important. But then, when people are not in the know of other ways to resolve their dispute, then it becomes an issue for them. So, we'll begin with arbitration. Arbitration refers to dispute resolution process in which the parties agree to an independent third party called an arbitrator to conduct a hearing and make decision on the merits of the case, which is also binding on the parties. There are some times that the decision may or may not be binding on the parties. We'll highlight that later. Arbitration actually emerged from itinerant merchants who, in a bid to overcome the delay of the court system, particularly with respect to perishable goods, were involved, usually involved tradesmen who agreed to submit their disputes to colleagues for the resolution of same. So just like in the case of Folari and Folake that I pointed at first, they have a watermelon and both of them are claiming to be owners of it. So they'll just agree that okay, a third person, maybe one of their colleagues, um, Shobole, would be nice enough to help them decide on who should take this watermelon at the end of the day. Arbitration is a private mechanism for resolution of disputes. It takes place in private between two or more parties. In Nigeria, the law that governs arbitration is the Arbitration and Conciliation Act. It basically applies to commercial transaction. So, what's this thing about arbitration and how is it commenced? For arbitration to actually take place, the parties must have prior in their agreement resolved that they would submit their in case any dispute arise, they would submit it to arbitration. It's usually placed via an arbitration clause in the general agreement, substantive agreement, or an arbitral agreement is separately created so that in case there is a dispute between the parties, they will quickly adopt such method in resolving it rather than go to court. And we've earlier highlighted characteristics and advantages of ADR. And discussing arbitration now shows us that there is a way in which parties can meet an amicable settlement. So, arbitration agreement, like I said, should be inserted either in the substantive agreement or a separate arbitral agreement is created that when a dispute arises, parties will submit such disputes to arbitration. And the person that governs the arbitration proceeding is called an arbiter. It's usually suggested that it can be one person or an odd number, let's say three persons. There are arbitral institutions that have been set up to cater for such needs of clients or disputants as the dispute arises. So when they sit down and discuss, they present their case, both parties present their case to the arbiter, and after reviewing same, he reaches an award. That is usually the judgment. In arbitration is called an arbitral award, which is given to the parties. And such award must have certain characteristics. It must be final, it must be time bound, it must be legal and possible. There's really no point giving an award that you know is not done. And an award must be within the contents of the substantive agreement. For example, if we said you ought to supply 200 tons of cement to someone and you failed to do that and they brought it before an arbitration and then the arbiter awards 400, which is not even part of it, then such award is not cogent or genuine. So Nigerian courts have adopted positive approach to the enforcement of arbitration agreements. A review of decided cases shows a general recognition by Nigerian courts of arbitration, or that arbitration is a good and valid ADR mechanism. So after an award has been given, it still has to be taken to court for the court to endorse it and make it enforceable. But the fact that the arbiter gave an award doesn't just make it final. It has to be given to the court so that the court can enforce it. From all indications, like I said, though award is final and binding to parties, it is not enforceable until it has been recognized by the court. So that's another thing that parties have to consider after awards have been given. We look at the qualities of an arbitrator. It should be someone who has good communication skill, someone that is competent, someone that is impartial. Because we've already stated earlier that one of the features of ADR is that it is confidential, and it's not good to appoint an arbitrator who is a blabbermouth. The truth is, you don't even get to hear of many arbitration proceedings until it's probably it's concluded, or it's at the beginning process, or probably it involves government governments. That's when you begin to hear of it. When it's individual based, you hardly hear of it. So, and then the person must be discreet. A good arbitrator understands the need to maintain what discretion, even in his decision making. He shouldn't take sides. He shouldn't openly declare that this person is the person who is to take the fruits, or based on a scenario. He shouldn't give an award ahead of time, taking sides. He must be discreet, independent, competent, a good communicator. And that's why there are trainings being offered for persons who are willing to be arbitrators. Arbitrators can be drawn from every walk of life, based on your skill and expertise. An arbitrator doesn't necessarily need to be a lawyer. An arbitrator can also be an engineer, depending on the knowledge and skill that you have in that particular area of relevance. Our next form of alternative dispute resolution is conciliation. It is a dispute resolution process in which neutral third party has the power to propose terms of settlement for consideration to the parties. So now, from our scenario, Folare and Folake, they approach someone to conciliate on their dispute. And what does the person do? The person can propose terms of settlement. The thing about ADR mechanisms is that they usually seek to protect the interests of the parties. Nobody necessarily seek to accept rights. So now you have a watermelon, and there are different parts of the watermelon. Okay, you have the peel, you have the seed, you have the fruit inside, and many of us that are conversant with such, we know that all of it can be used for various purposes. So if you actually sit down with Folari and Folake, you discover that maybe Folari doesn't really like watermelon fruit, like the inside, the red part. Maybe he actually wants to use the back, the outer part, for something else. So, and then you discover Folake actually likes the fruit and even the seed, and that's what she wants to consume out of it. So, you suggest that the watermelon be peeled, the back be given to Folare, and the other one be given to Folake. So, here the conciliator has the power. Who is the conciliator? The third party in conciliation is called the conciliator. He has the power to propose terms of settlement. He does this by discussing the issues in the dispute, making proposals to the parties of possible outcome, participating in the discussions on subject matter, and making his proposals. That's what he does. There. So how does conciliation work? Conciliation, parties must agree, should agree prior that they want this dispute to go under this process of conciliation. So the conciliator, when appointed, and in appointing a third party, it must be consensual between the two of them. One person cannot appoint another. So the conciliator, once appointed, may request parties to submit their statements, that's outlining the general nature of the dispute, to him. Then the conciliator assists the parties in an independent and impartial manner in attempt to reach an amicable settlement. The conciliator then guided by the principle of objectivity, fairness, and justice, gives his consideration based on the earlier document that was given to him as regards the dispute. Then he may propose settlement orally or in writing, and he will also invite the parties to discuss with them. Parties must themselves, in good faith, cooperate with the conciliator. The conciliator is not imposing, no, he's not imposing his suggestions, he's just guiding them, proposing. At the end of the day, it's up to the parties to decide what they want. So the conciliation clause needs to be inserted in the substantive agreement. Like it's like in all most ADR processes, parties must have prior agreed to it, or will agree to it after the dispute has arisen. All depends on the law that states it. So that's it for conciliation. So parties may choose to be bound by the conciliated agreement. It's not by force, so it's not compulsory. They may choose either to be bound by it. It's just a gentleman agreement that, okay, this thing you have actually said, it's good, we will go by it. and they can sign to that effect. The third form of alternative dispute resolution is mediation. This process involves an impartial third party who listens and directs the discussions but does not suggest outcomes. Basically, here the third party, that's called the mediator, listens to the parties in or the disputing parties and just tries to guide them. It doesn't suggest outcomes. Um, People tend to mistake conciliation and mediation. Like I said previously, conciliation, he proposes, he gives suggestions, but in mediation, he just sits, listens, and directs. Sometimes you see people are overheated and they want to pour out their mind. He acts as a calming person in the process. Um, the process can be distinguished from negotiation in that the mediator plays a role in preserving the process while the disputant take an active role in determining the outcome. The advantage of mediation cannot be overemphasized, as stated in Hasley against Milton and Milton Keynes, that the advantages of mediation stated that is usually less expensive than litigation. It provides litigants with a wider range of solutions than those available to litigation, and the continuation of existing professional or business relationship, perhaps on a new term. So you see how mediation is very important. It may occur where there is no intent to litigate. Like we mentioned earlier, litigation takes time. Litigation ends up destroying the relationship between parties. So people who do not want to go through all that stress opt for mediation. And the good thing is that mediation can even come in when parties have begun litigation, have gone to court. You see, the court suggesting, probably the court has gone through the documents, and you see the judge insisting or suggesting out of court settlement. They should they should arrive, they should settle between themselves. He has seen the possibility of this dispute being mediated and the possibility, but he doesn't want to delve into the arena. So he just tells them nicely, go and discuss. Go and discuss. So that's basically it. That's what mediation is all about. So there are notable features of mediation. Um, there are notable features of mediation. It's flexible, it's voluntary, nobody's coercing the parties. You say what you want, and it is acceptable to the other party, fine and good. It is neutral, okay? It is confidential, and it aids facilitation. The mediator assists the parties in towards a negotiated settlement, and it has party control, while the mediator plays an active role in guiding the parties towards the resolution. The parties are actively involved. The parties have the opportunity to bear their hearts. So mediation as a process also has phases, and there are four of them: opening phase, exploration phase, bargaining phase, concluding phase. So the opening phase is usually the first time the disputant meets as a group with the mediator, like a joint session. It's like a joint session. So the mediator explains his role as mainly a facilitator and not a judge, just someone who will guide them through, who will try to control the process while they bear their minds out. Then second phase is the exploration. That's the mediator sits with both parties separately, back and forth in separate rooms, listens to them. So the mediator can understand, a lawyer should understand that the mediator's goal is to achieve the conclusion, which is to the mutual benefit of the parties. So although the process may be rigorous, meetings upon meetings, the mediator's goal is to achieve the mutual benefit of both parties. Then you have the third phase, the bargaining phase. There are no fine lines between each stages in the process, but generally this stage can be said to begin when parties are ready to discuss terms of settlement in details. So they have explored, they have spoken to the mediator individually and collectively, and now they are ready to state what they want, the bargaining phase. Then you have the concluding phase. The goal of all mediation is to achieve a negotiated agreement which satisfies the parties and which deals with the issues in dispute, is workable, and it minimizes possibility of future disputes. When parties have agreed on the terms of settlement, the mediator will convene a final joint session and disclose to all and sundry who is involved. Another, though different type of outline for phases of mediation is pre-mediation, commencement of mediation, parties presentation, mediated negotiations, and agreements. So, you know, what has advantages always have a disadvantage. So, although mediation is good in itself, it has a pitfall when it comes to enforceability. It cannot be recognized um, and enforced by courts like judgments or arbitral award. You know, an arbitral award has to be recognized by the court for it to be enforceable. Its execution and implementation totally depends on the good faith of the parties. So, Folake and Folari, they have discussed and discussed, gone back and forth, and probably they even agreed though on the sharing formula of the watermelon. But then it's up to them to actually go through with it, because it cannot be it's not recognized by court like a way arbitral award or a conciliated agreement may be recognized. So there are a couple of qualities of a good mediator: listening skills, strong negotiation skills, the ability to create trust among parties, ability to identify issues of the dispute, patient endurance, because you need to be patient, because the people, the parties, they are aggrieved, they are unhappy, and this person is trying to assert his right. But you, as the mediator, have to know how to control them and bring out their respective interests. Common sense, rational thinking, neutral and partial. You shouldn't take sides. Is a likable person, experience in education and training, good people skills. You must also ask open-ended questions. You have to train yourself to be a good mediator or a negotiator, as the case may be, because it involves a lot, and there are institutes and trainings that can be done to improve on mediation. So our fourth ADR mechanism is negotiation. It is a process that simply involves two parties discussing and compromising to obtain an agreed solution. It is a non-binding form of ADR. It is communication for the purpose of persuasion. It is communication for the purpose of persuasion. So, parties may decide to undergo negotiation as a form of resolving their disputes rather than as a form of resolving their disputes rather than other forms. Like Folake and Folarin from our scenario, they can decide to negotiate, to talk together and reach a resolution or an agreed solution. So there are different types of negotiation. There is the interest-based negotiation where parties discuss based on their interest. There is a rights-based negotiation where parties discuss based on their rights, and then there is a power-based. You see, some negotiation require use of force. Yes, they require the use of force. So you have to be, you have to be Some negotiation require use of force, so you have to be firm. You have to be firm on your stance, but not force as in violence. Okay, so we have other hybrid processes which have developed over time in order to facilitate the process of alternative dispute resolution. And some of them serve as a support to the normal court process. You have case evaluation, mini trial, discovery referees, pretrial conference, med-ab. So case evaluation refers to where an expert, usually an attorney or retired magistrate or judge, provides a balanced and unbiased evaluation of, of the dispute. Pretrial conference or mini trial. Okay, pretrial conference, it happens, is a meeting of parties to an action and their attorneys before the court or prior to the commencement of actual court proceedings. In other climes, it's referred to as judicial settlement conference, in which judge or the judge or magistrate um, suggests that they go through that process rather than going through the full trial. The purpose of settlement conference is to try to settle the case before the hearing. Then mini trial is almost similar to a pre-trial conference. The trial has commenced, but then they decide to do an abridged version of it to ensure that the dispute is settled. Discovery referees is a form of dispute resolution mechanism common common to complex matters where there is an agreement between the parties relating to scope or subject matter of discovery. Well, these disputes are usually time consuming and emotional, but to improve the efficiency, the trial courts have the jurisdiction to appoint referees if the judge feels it is warranted in such situation. Med-ab. Med-ab is a hybrid process that involves the combination of mediation and arbitration. So parties, based on their disputes, may decide to opt for mediation first. They decide to opt for mediation first before arbitration. But when mediation has failed, then they go through arbitration. Like I said, mediation involves a mediator, while arbitration involves an arbiter, both appointed by the parties. So there are certain applicable laws. We have the Constitution of the Federal Republic of Nigeria, the Arbitration and Conciliation Act, the Ancestral Model Law, local legislation that refer to arbitration, like the Federal Competition and Consumer Protection Act, which provides for speedy redress of customer complaints through negotiation, mediation, and conciliation. We have the civil procedure rules of various courts. So these are some laws that govern arbitration. I must also point out that these forms of ADR are not applicable to all forms of dispute or matters that go to court. The common one is commercial agreements or commercial relationships. So you cannot apply any of these means of settlement or alternative modes of settlement to criminal matters, for example. Those ones must go through the full length of the law. But then there are moves that have been made. People usually say plea bargaining is also a form of alternative dispute resolution, but that's a discussion for another day. Then matrimonial, marriage, divorce related issues do not necessarily go through alternative dispute resolution.